versus the state et al. It's our number CV-25-0070. You probably heard me say this before. Each side has 20 minutes, and counsel just keep whatever time you wish for rebuttal yourself. And with that, please proceed.
Good morning, Your Honors. May it please the court. My name is Rebecca Baines on behalf of the state for the defendants. I would like to reserve about 3 minutes of time for rebuttal, if I may. This case presents a novel use of a wrongful institution of civil proceedings claim, but it is a fatally flawed one. In any WICP claim, a threshold element is whether the defendant had probable cause to begin or continue the civil proceedings. And so today I would like to discuss denial of dependency proceedings that underlie Ms. Stevens' WICP claim conclusively establish that probable cause existed for those proceedings, and two, why she cannot take that issue in this claim. So to begin, I would talk about what actually occurred in those juvenile dependency proceedings. And specifically, I think there are three events. So that was sort of the first event. The second event occurred later in the juvenile proceedings when the juvenile court, after a contested dependency hearing, found that the DCS had proven by a preponderance of the evidence that the children were dependent as to Ms. Stevens. And importantly, as I mentioned, that was a contested hearing. And that the children were being coached and manipulated by father as found by the court. So I think that's important because it shows that her allegation throughout or her position throughout those proceedings was that the abuse allegations could not support the custody or the dependency proceedings in light of the possibility that the children had been manipulated or brainwashed by the father.
Counsel, let me ask you a question about that. Because in a wrongful institution of civil proceedings claim, it's the initiation and then maintaining as well. And just because a plaintiff gets to argue at a proceeding contrary facts or calls out circumstances that in this instance the state DCS should have known of, why does it matter that she was able to make an argument at the hearing when the claim is about maintaining the proceeding?
Well, so I bring that up because I think that goes to the maintaining of the dependency process, and that when DCS was acting, it had a basis to do so, and that there was a judicial finding to that effect.
Well, let me pause you there because maybe I wasn't clear in my question. If the wrongful institution of civil proceedings claim includes a component that it was wrong to maintain the proceeding going from the initial ex parte order to the dependency hearing, why does it matter what was said at the proceeding when the claim is you shouldn't have continued it because you didn't have probable cause leading up to that hearing? I'm concerned about the focus on the hearing, because if that's true, then you never can have a wrongful institution of civil proceedings claim whenever a plaintiff was able to argue against whatever the defendant was claiming.
I think I understand your question, Your Honor, and the response is that what the events that occurred in the dependency hearing sort of illuminate the fact that probable cause did exist to remove the children and sort of to initiate or to maintain it up to that point, because at that point it shows, well, what would have happened sort of if these facts were called into question. That is, this allegation that they were aware of family court rulings and it wasn't disclosed, or that there was a reason to doubt sort of the basis for that. while the later rulings in the juvenile court and by the Court of Appeals show that there was a basis to find that because there were judicial rulings to that effect.
So you're saying that a subsequent hearing can cure what initially may appear to be a lack of probable cause?
Well, I think in this case, it just shows that there was probable cause in the first instance, that the basis for acting was reasonable, that the concerns of the caseworkers and their reasons for bringing the suit were founded, that there was a basis for those acts. So we are sort of aided by those facts that the probable cause did exist.
But isn't Mother's claim that that finding of probable cause, that very initial finding of probable cause, was flawed because the court didn't have the benefit of all of the information? And had the court had that information, the probable cause finding would not have been made at all.
So I agree that's her position, but I think we can say that that is not case and that that's not true as a matter of law because of what occurred later, that had the juvenile court had additional information in front of it, it would have done the same thing. And we know that because once the court was presented with that information, it found the children dependent. It allowed DCS to continue the actions and to affirm the custody orders that were in place.
Doesn't that beg the question then that if that dependency finding was subsequently vacated because there's information not brought to the attention of the court, then now the plaintiff gets to point to that and say, well, you may have thought you were okay because of what you argued at that point in time, but now we have a court saying, well, if I had known everything that I know now, I wouldn't have entered that order. How do we factor that in?
Well, I think it depends on what is it that you didn't know, and how does that information come to light. So in this instance, the dependency finding was vacated after the children ultimately recanted the abuse allegations, and the court said, well, knowing that now, I cannot continue to find the dependency. So in that instance, the later learned information does not change the fact of what these caseworkers knew or what a reasonable caseworker would have known at the time that they began and continued these proceedings.
Well, isn't that what we're supposed to be focusing on here, rather than taking the probable cause finding as essentially dispositive of the issue here? This is a motion to dismiss, and if this is sustained, then she will not have her day in court to prove her contentions. And isn't the standard whether, in this case, DCS subjectively believed that there was probable cause and that was objectively reasonable? It's the first part. What did they know? When did they know it? What did they disclose? That would be presented here. But if we uphold the motion to dismiss, that opportunity will never happen.
Well, it's true that if the judgment is affirmed, the WICP case would end. Of course, Ms. Stevens did have, an opportunity to, throughout the dependency proceedings, to contest it. But nonetheless, and yes, you're looking at what they knew at the time and whether there was objective probable cause and whether there was a reasonable belief in that. And even looking at the First Amendment complaint, I think there's enough allegations within the amended complaint that show that when DCS sought custody of the children, there had been an abuse allegation, that they were concerned not only about the abuse allegations, but also about Mother's ability to protect the children from the abuse or potential abuse.
But that's reweighing the evidence. That's not taking the motion to dismiss as true. If you look at paragraphs 18 through 22 of the motion to dismiss, it talks about a 17-day period in which first the family court determines that based on the father's pressure on the children, that custody should be restored to the mother. Then DCS files a dependency action, and within days, according to the complaint, which we're to take as true, within days files a report saying we have serious concerns about what the father has done to manipulate the kids that apparently were not presented at the dependency hearing.
Well, at the dependency hearing, I think so. We have the points that I testified that I read earlier that shows that she did contest the allegations on the basis that they were the result of father's manipulation as found by that court, which follows the paragraphs detailing what the family court had found. So I think it is reasonable to say, based on the complaint, that this information was presented to the juvenile court. We're aided by other allegations in the complaint that show that the caseworkers were upfront with the juvenile court about a number of things. One, about the fact that there was some family court order in effect. She talks about in paragraph 24 about the fact that an order of protection had been issued, but that there was a basis, had been a question as to whether that was substantiated. Paragraph 26, it reports that an abuse allegation had been made, but that was also unsubstantiated. The plaintiff did include in their motion for new trial some excerpts of the dependency petition that you can see in there what the caseworker told to the juvenile court. So, and I bring this up to say that this is not a case where the juvenile court was truly in the dark about the fact that this was not a cut and dry case, that this was a difficult case. That in April of 2020, when they asked for custody of the children, the children were no longer living in Arizona. They were not, DCS didn't take custody until a month later. So they had serious concerns. This is also detailed in the Court of Appeals decision that affirms the dependency, the kind of showing what went into this, including, history between DCS and the family from 2016 to 2020, the reports of a court-appointed advisor interview, reports to caseworkers detailing not only the abuse, but also the DCS's lingering concerns about Ms. Stevens' ability to protect the children. And even if it says in paragraph 15 of that decision that even if she did not believe the children, believe the abuse allegation, she needed to be protective, supportive, aligned with them so she could decipher as to why they were fearful of boyfriend. So that is really, I think, the picture of what was occurring in these proceedings. And then ultimately, the juvenile court considered this evidence, it weighed the evidence, and it found by a preponderance of the evidence that the children were dependent as to Stevens on the basis of what was known at the time.
So at this stage of the proceedings, we all understand that there was a judicial finding of probable cause at the custody and the dependency stage. And we, given the fact that it's a 12B6 dismissal, we take the facts as alleged in the complaint as true. So we also understand, and I think you would agree, that a judicial probable cause finding can be nullified if it was obtained as a result of fraud or perjury, correct, or deception.
Correct. We at least have cases to that effect in the criminal context, and there's some Ninth Circuit case law and similar.
Okay, so taking all of those premises, how do we resolve the case? It seems to me that we now look at every allegation in the complaint, accept it as true, and then determine whether probable cause was undermined or nullified by DCS's alleged omissions of information from the juvenile court. Is that correct?
That's correct. If these alleged omissions, or misleading or however you frame it, were material to the judicial decisions. So that's sort of the general framework, at least for the judicial deception cases and the criminal law cases, which it's framed, and of course we have a slightly different claim here. But I think there's also case law that shows that when you do have a probable cause determination, and we cited this in our supplemental brief, that was made after an actual hearing, that finding will prevent later relitigation of an issue in a later civil case based on the same arrest or the same action. Even when there's that allegation that there had been some sort of misconduct, some sort of fabrication, some sort of misleading statements, so long as there was an actual determination on those issues.
So do we make this decision as a matter of law then?
Yes, and this court's case law is also clear that whether probable cause existed is a question of law. So I think it's appropriate at this stage.
What do we do with the subjective element that Justice Bullock had mentioned? That did the caseworker actually subjectively believe, before you get to the objective decision, if it was a reasonable belief? So how can we resolve that as a matter of law at a 12B6 stage?
Sure. So I have 2 points on that. So the first is, in the Wolfinger case, which is a Court of Appeals case, the court there did cite a U.S. Supreme Court case for the principle that, in fact, if objective probable cause existed, You have to determine that first before you look at sort of the subjective belief in the merits of a possible claim. So there is case law to even suggest that really, if there's objective probable cause, that is, if a reasonable person, upon the facts known to a reasonable person, they would have believed that they had a good chance of establishing their case to the court. That language comes from this court's Bradshaw decision. Then that's enough. That would end the inquiry. So that's my first response. And then even as to how do you decide, assuming you concern with whether there was a subjective belief in the merits of the case, that goes to sort of my answer earlier as to what we know the caseworkers did know at the time that they sought custody, what information they did present to the juvenile court, and the fact that they were aware of that there was some potential concerns with either the credibility of the abuse allegations, some of this other history and allegations about surrounding, the orders of protection and the abuse allegations, that they were upfront with the juvenile court in their first report to the court about the fact that the children appeared coached to lie to the department. So even though they knew all of this, they still thought it was appropriate to seek custody of the children in light of what they knew. Justice Bullock, did you have a question? Yeah. Okay.
I've got one.
Yeah.
Or sorry, Justice Montgomery.
Go.
My
No,
apologies.
that's
go
fine.
first.
I'm going to go back because you're mentioning in reciting how the facts alleged by the plaintiff are supposed to be taken into account for assessing whether or not there was probable cause, and mentioning that they needed to be material and relevant to the judge's decision. At this point in a motion to dismiss stage, aren't we required to infer based upon the plaintiff's complaint that they were, in order to take that into account?
I'm sorry, that they were, I'm sorry.
Well, so, you were mentioning that if we're looking at the facts as alleged by the plaintiff in assessing whether or not there was sufficient information to determine probable cause, that there's one condition that those facts have to be material and relevant to the judicial decision.
Sure.
My question to you is, because we're at the motion to dismiss stage, aren't we to infer that they were?
I agree that because of the motion to dismiss stage, we have to view the facts in the light most favorable to the plaintiff, and we have to assume the truth of them. But nonetheless, I think that we also look at all of the allegations in the complaint, including the statements, that the removal order was sought and issued, that a contested dependency hearing occurred, that ultimately the dependency was found, and that ultimately the dependency was not vacated until the new report that was previously unavailable was presented to the court. So even applying the standards at the motion to dismiss stage, I think it is appropriate, and that the Superior Court here did appropriately say that probable cause existed as a matter of law based on what happened.
Well, that strikes me as inconsistent with both Bradshaw, which says if the operative facts are undisputed, the existence of probable cause is a question of law to be determined solely by the court. If the facts are disputed, the court may instruct the jury, telling them what facts will constitute probable cause. And the Franks decision in the judicial deception context, where the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth was included by the affiant, and if the allegedly false statement is necessary to the finding of probable cause, the Fourth Amendment requires that a hearing be held at a defendant's request. Obviously, that didn't happen at the time, despite the fact that the facts were vigorously disputed. How about now?
Yeah, well, I think that this case is slightly different in the Franks versus Delaware case and even the Bradshaw case, where sort of the nature of the underlying case, involved judicial determinations and findings that another party had sort of met its burden of proof along the way. And I think, and even in Franks, that you should have been given a hearing under the Fourth Amendment. That, it's our position that effectively that is what occurred in the juvenile dependency proceedings, that, once the children were located and taken into custody, and then she had the opportunity under the statutes and the juvenile court rules to sort of contest those allegations, in which, the complaint itself makes clear that both accounts were presented, and the court ruled on that basis. So I think that this is just sort of that novel and interesting context for these cases.
Under the 12b6 standard, though, can't we accept as true all of the facts, but aren't we entitled as a matter of law to determine the materiality of those facts?
Yes, you are. And your first point about, is there a question for the jury? We've argued that even accepting all of these facts are true, probable cause still existed.
Counsel, let me ask you one question about the Superior Court order here and the minute entry. It seems as if the judge just focused on whether or not there was an issue with probable cause at initiating the proceeding. I didn't see much treatment if recognition that the plaintiff's complaint also alleges that there was wrongful maintaining of civil proceedings. Even if we were to say, okay, there's enough probable cause here for initiating, shouldn't we return it to the trial court to allow the plaintiff maybe to amend her complaint and urge that let's focus on maintaining it?
So I don't think that the fact that the juvenile court didn't specifically address that argument necessitates reversal. And one, because I think that the rationale that the court applied would apply equally to those later findings. That is, it's recognition that the vacature didn't undermine the earlier rulings. And second, just the probable cause is a question of law. So if there's no further questions, I will ask you.
No, thank you, counsel.
Thank you.
I know you are out of time. I'm going to give you, though, another minute for rebuttal, and I'll add another minute to yours as well. So, we have a lot of questions for you. So please, Mr. Knowlton.
May it please the court and counsel, who I greatly respect. My name is Keith Knowlton. I represent Stephanie Stevens, who's present in the courtroom today in this massive pack of people, but she's here listening. I'm going to start with one issue, and then we'll hopefully from there we'll move through all these issues, because you know where I stand. I stand behind the Court of Appeals. Everything, answer your question, read the brief, read the ruling, because I thought it was excellent. It answered questions that I've had for a long time. But I want to deal with issue preclusion and equitable estoppel. That was raised in the supplemental brief for the first time as I know it. And my argument is obviously it should be held below before it comes up here and the court could deal with it. But the analysis that we go through with collateral estoppel and issue preclusion, I think is enlightening as to what happened in this case. First, there has to be actual litigation. My client has to actually litigate the issue of probable cause, has to actually litigate the issue of temporary custody. Show me where that happened. Anywhere in the record where that actually took place. You have the initial finding for the temporary custody order based on the declaration of the caseworker. Then that goes to, once the dependency is issued, then that goes to the juvenile court. The juvenile court said, okay, the children have been taken. We're trying to find them, taken by their father in hiding. We're trying to find them. And so let's not deal with your objection to the temporary orders. We'll deal with it when the children are found. That never occurred. You ended up in a dependency hearing and a dependency being found against my client.
Counsel, can we go back just sort of starting from the beginning, at least how I see this case? If we take her allegations as true, do we still not have a circumstance where in 2019, one court or one division of the court, the family court, finds that the children are not credible, but then 9 months later, circumstances have changed such that even though mother is supposed to have legal decision-making authority over these children, the children have been taken by father, they have been evicted from where they were living, they are living in a Walmart parking lot, later in the wilderness. Mother does not know where they are, they end up in another state. And so how do all of the circumstances that occurred, and now we're talking 9 months after the family court judge said, didn't find the children credible, now why do we not have enough for at least a probable cause finding, even if we take everything your client is saying as true?
I always focus in on the issue of abuse. You heard it. My client's boyfriend is in the courtroom hearing it as well. That's what the social workers were focusing on. He's abusing the kids. She's not protecting. He's abusing the kids.
Well,
She's not
just
protecting.
a moment. So, but even putting aside the issue of the boyfriend, she has legal decision-making authority over children that she doesn't know where they are.
That is correct.
So should the court have said, well, you know, father, we don't know where he is. He's not giving us access. He has been, lying about his place of residence, and we're not able to verify that the children are okay. Mother doesn't seem to be acting, instead saying, even though she doesn't know where they are, that they're probably lying. And the court is supposed to say, well, there's no probable cause, and so we're going to stay out of it.
Well, I guess I'm having a hard time following that, Your Honor. You had the allegations of abuse, and you had the family court pull the children in, interview them, and say, no, there's no abuse here. That wasn't presented up when they went in before the court to get the temporary custody order.
Right, and so there's 9 months that pass. So,
Right.
so first of all, is it binding on the juvenile court that the family court said, we don't find these children credible? That's the first part, and then second, have circumstances not changed in that time?
The circumstances had not changed in that time because it took till May for them to find the children in Florida and to get them in there. By then, they've already scheduled the dependency hearing, and they're going forward with the dependency hearing. I haven't found any notes, minute entries that reflect at all as to what the court's thinking was as to why we're waiting. Who's at fault for waiting? All I know is that the court documented that we were going to go forward with her challenge to the custody of the children, the temporary orders, once the children have been found. So
Right, that's what I mean. The circumstances had changed from July 2019 to April 2019. 2020.
yeah, there was loggerheads is the best way I could put it. My clients are saying, or my client is saying, no, we're not abusing. We're doing everything right. They're saying, yes, you are. But they know the family court ruling.
Did your client know where the children were?
No, absolutely did not. That's her ex now, the husband who the court was looking at the alienation that she was going through, causing the children to hate her mother, not want to be around her. That was still ongoing until they found him. And there was some services that had to be done once the children were found to deal with what the father had done. But mother couldn't do anything because she didn't know where he was or where the children were. She was assisting law enforcement to find the children.
Counsel, what do we do with in the Oglesby affidavit? There were other I find compelling allegations regarding your client, with her being diagnosed with a developmental delay, concerns due to her intellectual disability, that she was easily manipulated and not being able to take care of the children properly. That's outside of what was told to the family court. Isn't that enough in and of itself for a probable cause determination at that stage?
Your Honor, I don't think so, because the judge, the juvenile court judge, when he vacated, that was what the state said is, wait a minute, we've got these other issues that were raised at the time. That should meet our needs. And the judge said, no, they don't. Not in this particular case, because I would not have granted it if you brought it.
Well,
Counsel,
that was, I thought Judge Witten said that had he not known about the recantation, that would have upset the dependency finding. No one ever discussed the probable cause finding. And I see those two as distinct issues and distinct findings and facts that go into those findings.
I don't want to speculate or guess what another judge or what somebody else will do. I personally don't think there was anything there. And there was plenty of evidence to attack that as well. But, what we're dealing with here is that probable cause had never been adjudicated.
Well, Counsel, real quick though, I mean, the question that Justice Bean asked you, what he was alluding to is in the declaration that went for the ex parte taking order. And I think your response was referring to the dependency hearing. And I see those as two distinct as well. And just as a quick aside, I appreciate the argument you're making about issue preclusion or collateral estoppel. I look forward to the state bringing Crosby Garbutz back in front of us so we can deal with it appropriately. But that's not, I agree with you. That issue wasn't raised below, and it certainly isn't weighing on my determination. That was a hint for the state.
My understanding is the facts were the same, whether you're dealing with the probable cause determination, what was the factual basis for it, and for the dependency. They were the same. When the court set it aside, he didn't go into probable cause dependency. He just wiped out all the facts that were the basis of dependency, which wiped out all the facts for probable cause. You can't go forward and say, oh, I have probable cause when the whole factual basis has been wiped out.
Well, what about the fact that that the mother, as Ms. Baines pointed out, presented her defense at the or her position, articulated her position, and vehemently denied all the allegations at the dependency hearing, and the court ultimately found dependency by a preponderance of the evidence. So, doesn't that demonstrate that probable cause existed all along? I think that was Ms. Baines' argument.
I think it shows the weakness of our juvenile court system that they couldn't catch that. And if the caseworkers had been up front with the judge, would he have found it? Would he not? It's the same question. I don't think he would have found it. I think he's indicated he wouldn't have found it if he had known. So whether how do I restate the question?
So the mother so they had the temporary removal, and then they move forward with the dependency hearing. And at that hearing, the mother had a full opportunity to present her position about, the allegations that the children had made. She did, and she denied. She testified, as I recall specifically too. And ultimately, at that hearing, the court found dependency by a preponderance of the evidence, which is a higher standard than probable cause. So, does that not demonstrate that probable cause existed all along from the initial point, forward?
Well, I go with what this honor talked about, maybe at the beginning, but once you've gotten more and more and more from the family court, including giving her custody with those things we're talking about, he knew about those. So giving her custody just right before they go forward with getting their temporary custody order in the juvenile court. So our argument is that right then and there, by the time, as the Court of Appeals stated, at the time, at least one person knew of the allegations from the family court and that they were true. One of them. By the time we got to dependency, all of them knew that they weren't true. And that gets into the subjective, objective, and chance that would set aside probable cause. So
When the family court interviewed the children and reached the conclusion that they were subject to manipulation from father, did they ever recant their allegations of abuse?
no, not at that stage. The children did when they changed the social work caseworkers, and to those people, the children said, "No, everything we've said is false. It's not true. Our fathers manipulated us," and he brought that forward. The caseworker, when that was presented to the judge, he then ended the dependency, sent the kids home, and followed up on my client's order because she didn't want any basis of dependency that would any way form relate to her children.
But that was the first time that DCS had affirmative evidence, dispositive evidence that the children were not truthful when they leveled the allegations, correct?
Yes, but I think the judge would like to hear that another judge, family court, who's responsible for this, has already said these aren't. He can make his own evaluation.
But again, to Justice Bean's point, we don't know whether the family court judge was aware of the concerns that DCS had about mother's ability to care for the children at that time.
I think in our factual statements, there's some facts in there where they did know, where Judge Bean knew. He was acting on his own for things that he had heard. Now, if we get into a trial, we find out all of that stuff and gather up all that stuff. But he was acting on his concern from what was happening in his courtroom.
One thing that no one's talked about yet is the restatement. I mean, generally we follow the restatement unless it's inconsistent with Arizona law. And Restatement 675, comment B has been brought up, different than issue preclusion, although kind of close. and it says, at least comment B says, that in the case of initiation of criminal proceeding, a decision of a competent tribunal, here the juvenile court, in favor of the person initiating civil proceedings is conclusive evidence of probable cause. And so I look at that, if we adopt that, then I'm looking for, okay, we don't have to relitigate whether there's probable cause or not. It was already decided by the juvenile court, unless some information that would, I think as Justice Lopez put it, or Vice Chief Justice Lopez put it, would diminish or belittle or something, or take away, remove probable cause, was withheld by DCS. So it's important to me, at least, what information, according to the complaint, was withheld from the juvenile court in the dependency proceedings.
And I believe it's around 15, 16, 17, 18 paragraphs in the amended complaint, which I provided to the court. Clearly, he knew of the allegations of abuse by Joe. That he knew. He if I may.
Sure.
It's always tough to see, Your Honors. Then at 15, at all relevant times, Stephanie was in family court custody battle with her ex-husband, and I'm not going to mention the name or the case number. And then paragraph 16, on February 14, 2020, Judge Blaney, on his own motion, entered temporary orders because of his concern that father was manipulating the children to alienate the children away from Stephanie. I think that needs to be taken into consideration on these other allegations, the alienation that took place.
If the judge, and I can't remember who was it, Judge Whitten, maybe on juvenile, had he been told of Judge Blaney's concern, would the probable cause be lacking?
I didn't hear that, Your Honor.
Would probable cause have been lacking if Judge Whitten had known of Judge Blaney's concern in the family court matter?
I think so, Your Honor. I think the judge post has indicated what he would have done, but what he would have done at the time, at least the evidence, isn't that what we're asking for? That when caseworkers are doing their job, that they present the full picture. They don't pick their parts of it they like and keep the rest away from the judge. And that's what this case is all about, and why we have pursued this case, is the caseworkers need to be responsible for maintaining the ethics of the system. And that was one of the things I found very interesting in the Superior Court, the Court of Appeals ruling, because it's talking about the impact on what the judges are supposed to do. The judge here is to take custody of a child to protect the child. And if you don't give the correct information, you are damaging the system.
Yeah. And I think what I'm concerned about, at least, because we're going to be writing an opinion about this, obviously, and it's going to guide the future cases. And the caseworkers are going to be reading this. And it's a concern that they will hesitate, perhaps, to protect children if they're worried about being sued down the line. So what lines do we draw for them to know? Should they be saying, make sure the judge knows absolutely everything that you've learned and absolutely every suspicion that you might have or doubts you might have on credibility of the various people? You see where I'm going? So what would you propose that we should be writing to give that kind of guidance?
One of the rules of 40 years of practice, when in doubt, do. When you don't know, do. If you are honest, that's the biggest key. Just be honest. Tell the story. Let the judge make the calls. Don't try to influence the calls.
But here, what was I sensed, at least from the complaint, it wasn't a matter of dishonesty as much as omission. You didn't tell enough. You should have mentioned the family court situation, which I actually agree, they should have mentioned. To do the best job, they should have mentioned that. But but I didn't know that I didn't see any allegation that was dishonesty in that. So again, and I interrupted you on it, but what line should we draw there?
Well, the Court of Appeals, and I think it was one of the compelling arguments, was that they consciously hid those facts. That's a whole different story that the Court of Appeals has found as a basis for sending this down to give us an opportunity to try the case, is that the Court of Appeals findings of those facts had that kind of an implication, which is to protect the sanctity of a court system. If we're going to have judges enter orders to take children into custody, they need to have confidence that the information is everything that the caseworkers can have, and that the caseworkers are in good faith presenting that to them.
Well, the standard that I quoted before from the Bradshaw case and the Franks case, those are really tough standards to meet. If we conclude that the motion to dismiss was inaptly granted, and you get a shot at this, it's not going to be easy to show that that DCS actually withheld information, or, to Justice Montgomery's point, continued to maintain an action after the factual basis for it largely dissolved. So isn't the right answer that the standards that have been articulated both in the wrongful institution of civil proceedings context and in the judicial deception due process context they already exist, and they haven't chilled the profession?
I will concur with that, absolutely, Your Honor. Those rules work, and they give my client an opportunity to raise the question and litigate if she can meet the factual burdens. And in this particular case, I think she can. Anything else, Your Honors? I'm done.
Thank you, Mr. Knowlton. Okay, Ms. Baines, 1 minute.
Thank you, Your Honors. I'll just conclude by saying that this was a case where the circumstances that existed and the facts known to the caseworkers supported a reasonable belief that temporary custody was necessary, and that there was a basis for a court to find that the children were dependent, and that any reasonable person could have so concluded, and that the later rulings by the juvenile court established that probable cause existed, and that this is true even in light of the family court rulings that were issued either weeks or months earlier, and that even if those findings had been presented to the juvenile court, that the same result would have occurred. And that the later vacature ruling did not wipe out the prior factual basis and did not undermine those earlier rulings. So I would like to answer any further questions. Otherwise, we ask that this court would affirm the judgment. Thank you, Your Honors.
Thank you, Ms. Baines. Okay, we will take I want to thank counsel for their arguments today and their briefing. We know this is certainly a serious matter we will take under advisement and issue a ruling in due course. Now, next, I want to thank also counsel, as I did, you probably heard me the first time. Thank you for coming to Holbrook. It's a nice opportunity for people here to see real cases in action and to hear lawyers such as yourself who did a fine job answering our questions and having to think on their feet for some of these things. So we really appreciate it. The next thing we're going to do is have a question and answer. You're welcome to stay. You're welcome to leave. We won't be talking about this case, I can assure you. We will move then to question and answer. So I'd ask, I guess, that the lights come up, because right now you guys are all shadowy little figures out there. People, okay. Oh yeah, they're going to take this away first. I know.
That we had this morning, and once in a lifetime.
been in education a very long time and never been able to watch what you just watched today. So make sure you take that into account. This was a great opportunity. Let's first of all, we have a few questions from our students, but we also want to recognize where our students are from. So maybe just raise your hands, and if you've got a rally cry or whatever, we're high school kids, right? So Blue Ridge, where are you at? Blue Ridge. All right, this is the Blue Ridge Yellow Jackets. St. John's. St. John's, all right. How about Sholo? Sholo, where are you at? Sholo Cougars over here. And we have Snowflake Lobos, where are you at? And do we have some Holbrook Roadrunners here? Yeah, home court advantage there. We also have some justices that we want to recognize. If you're a local justice, could you stand and be recognized, BJ? Yeah, Ms. Wilkinson, let's give them a big round of applause as well. Okay, we'll start with this. What's that? Winslow, I'm sorry, Bulldogs. Boys and Bulldogs. They're our rivals. I'm sorry. I didn't intentionally do that, I promise you. Maybe we can start with the justices because I believe that the students would really like to know who you are, your name, where you went to high school, I think is always important, and then where you went to college. So, Justice King, you want to start?
So I'm sorry, I missed my name and where I went to high school and when. Okay, thank you. Yeah, so my name is Kate King. I'm actually a native Arizonan. I was born and raised in Phoenix, but I actually, as I noted at dinner last night, I spent a lot of time in Sholo and Pine Top as a young child. I went to Xavier College Preparatory in Phoenix for high school, and I went to Duke University in North Carolina for college, but then came back to Arizona, University of Arizona for law school.
Thank you, Justice King.
And we still morning? Good morning. My name's James Jean. I went to high school in Santa Barbara, California, Dos Pueblos High School in Santa Barbara. I went to undergrad at UC Santa Barbara and then went to law school at the University of Arizona. Finished there in probably before your parents were born in 1991. So.
Good morning. My name's John Lopez. I am a native of Texas. I went to high school in Houston, Texas. I got my undergraduate degree at the University of Texas, but I went to law school at Arizona State University, and I have lived in Arizona longer than I lived in Texas. So this is my home.
Good morning. I'm Ann Timmer. I went to high school at Arcadia High School in Phoenix, and I went to undergrad at University of Arizona, to law school at Arizona State University, and because I really loved learning, I went, after I became a judge, I went and got a Master's of Judicial Studies at Duke University School of Law.
Good morning. My name is Clint Bullock. If you've ever watched The Sopranos, that's where I went to high school. And I went to Drew University in New Jersey as an undergrad. I decided to flee New Jersey and went about as far as I could on the other side of the country for law school at the University of California at Davis. I now teach part-time, of course, law school at the university, at Arizona State University School of Law. And even though I practiced in Denver and then Washington, D.C., my wife, who is now a state senator, Shauna Bullock, convinced me that I really belonged in Arizona. And it turns out, as with most things, she is right.
Hi, I'm Bill Montgomery. I graduated from Paramount High School in Paramount, California, which is right next to Compton. My undergrad was at West Point, And I went to law school at Arizona State University and started there in 1998 when my wife and I moved here to Arizona.
Hello, good morning. My name is Maria Elena Cruz, and I grew up in Yuma, Arizona, the southwest corner of the state. I graduated from Yuma High School, and I'm a proud Yuma High criminal. I then went to Arizona Western College, our local community college, go Matadors. I was going to be a teacher until I had contact with an attorney for the first time, and that led me to think, I can do what he's doing. And I hope that happens for at least some of you today, that maybe you're not sure exactly what you want to do. That's a normal part of this stage, trying to decide what you want to do for a profession for the rest of your life. And hopefully having contact with us and our law clerks. If you see the row in the front here, these are law clerks for the Supreme Court, maybe asking them questions about what they do now, what they hope to do in the future might be of interest to you. After um, after having that contact, I transferred to the U of A and finished my undergraduate studies there. Go Cats! And then I went to the U of A Law School. So I'm a double wildcat.
Excellent question, Abby. I am currently, I serve on this court as the Chief Justice, which means two things. I get to sit in the center of everyone, and I get to delegate when I want to these folks. So I'm going to delegate that question to Vice Chief Justice John Lopez, and I'm going to do this in an order for everyone. In order, we always go reverse or by seniority down. So I'm going to start with Justice Lopez.
So there were two questions, and the answers are yes and no. That's a joke. The first question is, have you ever come into court believing that you know how the case should be resolved? And the answer is generally yes. We spend weeks preparing for oral arguments, reading all of the briefs and the record, and we get memos from our law clerks to help us figure out the case. And so we spend a lot of time preparing. And I think it's probably true of all of us that we even will draft out pages of analysis resolving the case the way we think, without having heard from the parties in oral argument how we would resolve the case. So my view is we're not fully prepared unless we've thought about the case so carefully that we're prepared to present to our colleagues in conference after oral argument how we would resolve the case. Now, having said that, there are times where we change our minds based on what we hear from the lawyers in oral argument, like you heard today, but also, and perhaps even more frequently, what we hear from our colleagues, because we generally don't discuss the cases with the other members of the court. And so sometimes we don't even know where the other justices stand as we come in. And I think we do that because we don't want to be influenced as we're preparing. We want to reach a resolution that we think is the best one. And then we listen very carefully to our colleagues, always with an open mind, because our main purpose, our main goal is to get the right answer, to get the best answer that's truest to the law and consistent with the facts applying to the law. And so, yes, we come in prepared, but also, yes, sometimes we will change our minds as we discuss the case with our colleagues in what we call conference, which is the meeting where we all decide the case and vote, usually right after oral argument. So great questions.
Okay, the next question comes from David Lopez. David, if you stand up, from Winslow High School. David's question is, how has the government shutdown affected the work you do?
Oh, yeah. We're still here. All right, I'm going to turn this over to Justice Bullock, who is next to me, the next most senior on the court.
Yes. Well, that is a great question, and boy, I lucked out because it's really easy to answer, and the answer is not at all. That's the federal government, and this is the state government. And I won't make any. Yes, I will. I won't make any snarky comments about how we do get our budget passed.
Okay, the next question is from Mildred McGuire, also from Winslow High School. Mildred. Her question is, why did you decide to lower the bar minimum for rural Arizona but not for Maricopa County? And this is in reference to AO 2024-148.
Well, that's a very specific question. Okay, then I will reach over to, not happy about it, Justice Bean. Can you answer that? Lowering the bar, you mean to get into the practice of law? Is that it? That's going to be an easy answer then, because we didn't do that.
Yeah.
Go ahead.
We didn't. A few years ago, we did lower what we call the cut score, the minimum number of points you needed to achieve in order to pass the bar, and that's statewide. You might be thinking about how we have a program that if you get between the cut score is 270, if you get between, I think it's 260 and 269, you can enter a program that we approved, I think last year or the year before, that allows you to work in a rural county such as Navajo County if you are if you partner with, so to speak, if you work with a licensed attorney, and they help you during the practice of law. And I believe it's 3 years. Is it 3 years? 2 years. If you work in that apprentice situation, then after 2 years, and I think a subsequent application, and the person that's supervising you attests to your good character and that you're ready to practice law, then you can become a member of the Arizona State Bar without achieving the score of 270. So we did that, and I would ask my colleagues to chime in on this because we have what we call a legal desert here in Arizona, as opposed to we're also a natural desert in some areas, but we have a legal desert. We're 49th out of 50, the 50 states in terms of attorneys per capita. And that's not great because we want every citizen in Arizona to have the ability to access our justice system. Where that really kind of hits home more than in the metropolitan areas like Phoenix and Tucson is in the rural counties, places like Holbrook. So we wanted to create this program to allow lawyers that, again, did not achieve a passing score to come out here, practice with an attorney, learn the ropes, get some experience while they're still practicing, and then after 2 years become full-fledged members of the bar. We wanted that because we want to attract people to the out counties. I worked in a rural county right out of law school in Pinell County and found it to be a fabulous experience and got great experience during my time there. So we did that to attract people to the counties that don't have a lot of attorneys. So Mildred, I hope that was responsive to your question.
Oh, yeah. I was going to ask something too, but go ahead.
I agree with everything that Justice Bean said, and I would add one small fact. Our passing score at 270 is the highest in the country, and other states have that as the pass score too. But 260 is also the passing score of many states in the country, including two of our neighbors, Utah and New Mexico. And so when if there's a concern that we're sending lesser qualified lawyers to our rural counties, I just want to say that that score is the passing score in many states in the country. So these folks could walk straight into New Mexico or Utah or many other states and begin practicing with a 260 score. And so a 260 score is generally recognized as a score that will only qualify qualified law students to become capable lawyers.
And, and Chief, if I may add one additional point, I believe that the program applies statewide to public sector attorney positions. So actually, the program has statewide applicability, and so there's many public sector entities that are in need for lawyers statewide, and that applies in all 15 counties. So the program applies statewide with respect to those positions as well.
Our next question is from Jacob Martinez. Jacob Stan from Winslow. Jacob wants to know what your thoughts are on the construction of the ballroom in the White House.
This is Justice Montgomery. Please.
I'm interested.
So the great thing about being a state Supreme Court justice is that my focus is on state matters. And so I don't care what happens in Washington, D.C. I care about what happens to the people I represent in Arizona. Yeah. And last I checked, we weren't tearing down any part of the state Supreme Court building, so we're good.
Well, we've got all kinds of unsolicited advice to give to all of you, I'm sure, just as I do for my own children. One piece of advice, and why don't we go down the line on that one? Let's see, who are we up to? Kate.
Excellent question. Well, one thing, you are all in school, and I think your focus right now should be studying and learning and taking advantage of academic opportunities. I mean, frankly, the fact that all of you are here, just the fact that even if it was mandatory in your school, but nonetheless, the fact that you're here and taking advantage of those opportunities to open up your eyes to new and different learning experiences, and opening up your eyes to maybe a profession and a career that you didn't necessarily think about in the first instance. So that would be one thing, is really you're at a phase in your life where you're absorbing so much information, and take advantage of that in your respective schools. The other point that I'd make is to act with integrity and ethics in everything you do, because your reputation starts now. Decisions that you make now, believe it or not, will move forward and carry with you for the rest of your life. So keep that in mind in all that you do. But I really do. I want to thank all of you for being here. It really warms my heart to see so many students here today. Thank you.
And Justice Cruz, I think we're reaching towards the end, I gather from that, so I want you to be able to speak, so please, why don't you answer the same question?
Thank you. Yes, I speak last because I'm the most recently appointed justice and we go by seniority, so I'm always last. But I'm not bitter about that. My advice is similar, a little bit of a twist to what Justice King just mentioned. When I told you that I grew up in Yuma and I moved there at 14, what I didn't tell you is that before that, I was born in New York, and then at a very young age, we moved to Puerto Rico. My dad's Puerto Rican. And I lived there till 14 and then moved to Arizona. I didn't speak English. And for a lot of reasons that we're not going to get into right now, there was not a plan for me to go to college. So when I was in your shoes, the thought of doing what I'm doing now was completely out of the question. Completely out of the question. A number of things happened along the way that changed that for me. So my advice to you would be to think beyond whatever limitations exist in your life that you have not chosen, what other people around you think you should be doing. Set all of that aside and think about what would make you happy. What would you like to do with your life? And no matter how crazy it sounds, trust me, when I gave myself permission to dream, to do whatever, I thought, if I ask myself honestly, what would I do if I could do anything in the world? I thought I would be either a doctor or a lawyer. And then I thought about that a little bit more and I thought, I don't want to be a doctor. I don't want to be in people's cavities and all of that. I gave me the ick, but I can argue about that. So ask yourself that question. If I could do anything at all, wake up tomorrow and be anything, what would that be? And then start to work towards finding your way towards that. Doesn't matter how incredible it sounds, everything is possible. Find people who have been where you are and who want to support you because we are here. And hopefully, I know I'm selling the profession like I'm getting commission on lawyers that come into the profession. Trust me, I'm not. But it's important to me that I see the state of Arizona, the lawyers in the state of Arizona reflect the entire state of Arizona. That not all the lawyers are in Maricopa County or in Tucson, but that the northern Arizona and all other parts have the representation, because believe me, right now, the thought of a lawyer and not a lot of representation may not matter from where you are, but it matters when you need one. When you need one, okay? All right, so that's my advice to you. Give yourself permission to do anything.
Sure seems that way. So again, give yourselves a hand.
Hey. Thank you. Mr. I actually I want to also thank you on behalf of the court, all of you, for one, you're a terrific audience for listening to this, and we really appreciate your attention. We know that maybe this wasn't, insurance might not be your thing and such, difficult to follow along with this. But very quickly, I wanted to thank also the people on our end that made this possible, and recognize some people. First, I think they were alluded to, our law clerks. We hire two law clerks of peace that they most always are immediately out of law school. Some have practiced and come back, but they're all lawyers, and most of them are starting their practice. So please stand up, and so you can be acknowledged. Yep. Yep. And briefly, I have an ask for all of you, and that's this: and I speak to you really not as adults to kids, because you guys are all like adults in my view. You're young adults, and we've reached a point in our country where you can't take democracy and the great things that we have for granted. We have issues in this country, but we have a terrific framework and a process, and I still think the best in the world. What's important I think I speak for all of us, is that you all understand that and take ownership of what is rightfully yours, which is this is your legal system, your legal branch, your government. And part of that is understanding what it is and what it isn't. So I'm thrilled that you're here today to see the legal process, and you can see what we do, and you can see that from a lot of our questions, if you were listening, it's not maybe how we want the world to work, because that's not what our job is. Our job is to uphold the Constitution of the United States and the constitutional laws of the state of Arizona and fairly apply them. But we don't get to make policy. We're not a second legislature. I think you all need to take ownership of this, meaning you need to understand what each branch does. It's not the sexiest thing to do. It sounds like homework and all of that. But this is the world that you live in, the country that you live in. And whatever you want to make it, you have to first understand what it is and how it operates. And I truly hope, I echo what's been set up here. I hope if any of you, raise your hand if you have any inclination to be a lawyer someday. Oh, yay. I'm so happy that you do. It is a gratifying career, and I hope that you pursue it. And if you truly are, as you get to be an adult, and if you ever need any advice or whatever, you're free really to call the court and ask. Any of us would be happy to tell you, and any of these young people here, I think, would be happy to tell you their experience. So thank you so much for that. That's my little diatribe on that. I also want to give a thanks to everyone here at the court that made this happen. It's a tremendous thing for us to come out of our usual court building. So I want to thank the AOC leadership and the staff who helped coordinate our oral arguments on the road, including our AV department, because we were live streaming this still, our clerk's office, our security officers, and our communications team. So please give them a hand for me. I also want to give a thanks to, of course, Holbrook High School for hosting us, and then all of your schools for bringing you here. I know that's a huge undertaking too, and interrupting your school day, so we really appreciate it. And also Superintendent Robbie, I hope I get this right, Corporich, right? And all the school leadership who helped plan and host this. One thing that we like to do is give a gift to a school to kind of leave a little token of our visit. And so I wanted to give, but we're government and we don't really have much, but we do have a picture of us, which is just great, that we love to give away. So Mr. Corporich, if you could come down, I lost track. Oh, there you are. And while he's making his way down, I also wanted to ask the local judges here. I see presiding judge in Navajo County, Michela Rickle here. Michela, can you please stand up? Yep. And I know a couple of the JPs stood up, but also Susie Delson, I saw here. All the judges, please stand up. Let's just make that easy. All the judges here from Navajo County.
I know I'm totally out of order while the chief's away, but if you want to find out what happens in these two cases, follow us on social media and you'll get to find out.
Okay, I think finally with that, we stand adjourned.